copyright subsists in the original literary work, it is not necessary that the work shall be the expression of the original or the inventive thought, as the copyright is not mainly concerned with the originality of the idea, rather it is impressed with the originality of the expression. Original ideas are not protectable under the Copyright Act. Original expression is protectable under the Copyright Act. The original work shall be the product of the human mind, which shall be consisting of several verbal or the numerical statements and the personal effort of the person. In the landmark case of the Macmillan versus Cooper, it was held that if on any raw material, someone by the use of the labor, skill, or the capital of one man, which must not be appropriated by the another, not the elements, not the raw material upon which the labor and skill and the capital of the first had been extended. In the Indian context, the concept is being incorporated in the Section 13, Clause 1 of the Copyright Act, which states that the copyright must subsist in the original literary, musical, dramatic, and the literal work. The doctrine of the suite of the law states that originality does not signify novelty. A work may be original even though it resembles other works. So, as long as the similarity is fortuitous, not the result of the copying. It was held in the case of the Feast Publications Inc. versus Rural Television. An example of this doctrine was seen that the person who complies with the database must have a copyright over the product, not because such a compilation of data showcases any creativity or the author has expressed anything original, but merely because of the effort, time, as well as the money invested by the creator to collect and organize that data. But that compilation of the data and the figures and the stats shall be the work of the creator only. It states that the notion behind this was that in the compilation also the effort is there, the creativity is there. So for effort and for the creativity, we can consider that the copyright can be given. Alright, now let's see what's the Indian stand in this. Now, in the leading case of the Eastern Book Company versus D.B. Modak, the Supreme Court stated that the compiler's selection and the arrangement has to be protected. The court stated that the doctrine of the sweat of the brow, the court here rejected the doctrine of the sweat of the brow, and the court was of the opinion that this doctrine creates a monopoly in the public domain, and the monopoly is created without giving a proper justification or encouraging the creativity of the authors. Now, fact of the case was that the EBC was the publication house and it used to publish a book named Supreme Court Cases. Now, where they used to publish the judgments of the Supreme Court, and a team of assistant staff of the appellant used to also give various insights and certain comments on that particular judgments. Now, the respondent came with a software package which was known as the laws, and he published these judgments on the CD-ROM, and they have also copied the manner they published the Supreme Court judgments, and they also copied the manner in which the EBC book Supreme Court Cases was being published. And the Supreme Court states that yes, they have copied the concept and everything, and so it was held guilty. Now, the another question before us often arises regarding originality is that whether is it different from the minimal creativity approach? Then yes, they are different, as the sweat of the brow entirely focuses upon the labor and the effort of the compiler, as we saw in the earlier Macmillan case, that how it was of the view that if the compilation if the data are same and the compilation is being done with a different manner, like in the doctrine of sweat of brow, then we can state that that work is also eligible for the copyright. But as per the minimal creativity, we see that there shall be some level of intellectual creativity so that the work can come under the ambit of the copyright. So there are two things which needs to be considered when we talk about the copyright and the matters which can be the subject for the copyright or not. First, originality and creativity. Doctrine of sweat of brow only focuses upon the labor and the effort and do not consider the originality and the creativity. Thank you.